what I'm that information. So thanks again for being here today, and I'm going to turn it over to Shane.
Thank you, Vivian, and thank you, Patrick, for being here with us today. People are still coming in. That's awesome. So we are recording today. You probably just got that little notification pop up there. So if you want to get the link to this recording, please let Vivian or myself know, and we'll make sure to get it. I gotta get it downloaded. It'll be a Dropbox link, so you'll be able to go into Dropbox and pull it out or view it from there, or whatever you need to do. But for those that don't know me, and hopefully all of you do, my name is Shane Sauer. I'm sales manager here at Greystone Title Agency. I do partner up with Vivian quite a bit on a number of events. We got all kinds of good stuff planned for the rest of the year. So if you're, make sure you're getting those emails and make sure you're attending. A lot of good stuff. We're big believers in realtor education, and having Patrick with us monthly is a huge plus. I mean, guy's amazing, right, Patrick? I'm just gonna pump you up, man. Put the cape on. Let's do it. But anyways, my job here at Greystone is marketing. So if you're looking to do some marketing, if you're not getting the support that you're looking for, the title company you're working with, please, 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 let's sit down and chat. Awesome staff at all of our offices. I'm based out of Chandler, but I do cover the whole valley from here. I'm pretty much everywhere, you know. Yeah, we've got a lot of good tools here. If you're following me on Facebook, you've been seeing market valley stats and stuff that I've been posted out there, stuff I can share with you to get out to your clients as well. So keep me posted. I will follow up. Let's try to set an appointment, maybe grab coffee, lunch, whatever we need to do. Let's chat about your business. I want to see what we can do to help you really get better as we move into fall, because I think it's going to be a very busy fall. So stay tuned for that. With that, I'm going to turn it over to Patrick, because Chris is not here, right? I haven't let him in.
Yeah, I haven't seen him, and as far as I can tell from our phone conversation or text, he's still having technical issues.
Well, let's make fun of him.
No, this is like, I don't know, Acme computer he's using or something. I don't know.
Yeah, been there, done that.
Tell him to get a real computer.
Yeah, right. Well, let's turn it over to Patrick. Let's get going today. And like I said, we are recording today. So if you want the link, make sure to let us know and we'll be sure to share it. Thank you, everyone.
Thanks, Shane, and thanks, Vivian. If we're recording, we might not want to say too much about Chris. Maybe we throw it all into the chat and disparage him that way. So anyhow, for those of you who don't know me, my name is Patrick MacQueen. I'm a real estate attorney here in Arizona. I've been doing this for 17 years. Our firm handles all sorts of real estate matters, whether that's real estate transactional matters, whether that's real estate litigation. Chances are we've done it, we've touched it. And in setting up today's discussion, I started looking at all of the recent cases that have come down that may affect real estate agents or that may affect the real estate world. And I came up with the top 3 or 4, but in reality, there's probably 8 to 10 things. And so that's why there's a comment in the chat box about perhaps putting part 2 together. That may be something that we ought to consider, because there are a number of new statutes, there are a number of new judicial interpretations that we've got this year. I'm going to go over the top 4 or so today, but again, there's more than this. And I'll probably put together some sort of comprehensive memo that outlines all of these issues. And so if you want something like that, you're more than welcome to ask, and I'll put it together. Before I jump into the new cases and the new statutes that we've seen, I'll pop up a share screen here. Let's see. This is just a very basic outline of the items for today, but I do want to get into briefly, before I get into to all of the new cases, I want to tell you guys about what we're seeing really quickly. One of the legal trends that we've seen, and I've mentioned this on some prior calls, is there's this huge push for requiring that agents have their own PLLC, professional limited liability company. A lot of brokerages, and maybe you've heard this, maybe not, are pushing agents to set up a PLLC to operate their real estate business. I'll tell you why. there were some cases, we're talking about cases today. So there were some cases from about 2 or 3 years ago in which the National Association of Realtors was sued, in which a number of big brokerages were sued. And the issue was whether real estate agents are independent contractors or they're employees. If they were employees, which is what these real estate agents wanted to be considered, then they were entitled to certain employment benefits, unemployment, insurance, perhaps 401k, those types of things. Those cases ultimately settled, okay? And so we don't really have the court's interpretation of whether a real estate agent is truly an independent contractor or is truly an employee. What we have are some brokerages who were freaked out about that situation, freaked out about the fact that real estate agents may be deemed employees. And so now there's this big push for real estate agents to set up a PLLC. If you're feeling the push, maybe you are, maybe you aren't, maybe you're not one of those brokerages yet. I have a checklist of things that you need to consider and you need to do to set up a PLLC if that's going to be required of you. The rationale behind setting up a PLLC, or the rationale behind a brokerage requiring that an agent operate through a PLLC, is very simple. If you're operating an independent business, your PLLC, you're an independent contractor. You're not an employee. So that's why there's that push. And so if you're getting some push, let me know. We'll get you that memo, and it kind of goes through the step-by-step process for you to set up your very own PLLC and to do it properly. Okay, so that's issue number one. We're seeing that happening a lot. PLLCs are great for asset protection. There's also some tax benefits. So even if your broker isn't pushing those, I still think they're usually a good idea. Second hot topic, which we probably mentioned at the prior class about a month ago, are these lawsuits for what's called specific performance. Specific performance refers to a judicial order that you can obtain, that a buyer can obtain, if a seller is refusing to sell. And so in this market, we're seeing some sellers who are refusing to sell. They enter into a contract with the buyer, and then they realize, whoops, I could have got a little bit more for the property. I could have got $100,000 more for the property. I'm not going to sell to this particular buyer. Well, they really can't do that, okay? And so in a situation like that, what a buyer should be doing is they should be filing a lawsuit for specific performance. They should be recording a notice of lis pendens so that that seller can't go out there behind their back and sell that property, because once it's gone, it's tough to claw that thing back. It's tough to get it back. So that's another issue that we're seeing quite a lot of, okay? So hot issue number one is this push for PLLCs. Hot issue number two are these specific performance situations. And there are different things that you can do. Should you send a cure notice if the seller is refusing to sell? I don't think you actually have to. If it's absolutely clear that this seller is saying, I will not sell to this buyer, then you need to proceed to a specific performance lawsuit, record a notice of lis pendens immediately. If they're kind of hemming and hawing, well, then you can send a 3-day cure notice. But what we're trying to do is protect time here, because if that seller goes out and sells to somebody else, getting that property back is going to be very difficult. But by far, guys, the hottest issue, so those are the top 2 or 3 or so, the hottest issue right now are misrepresentation claims. And I hate to say it, but we talked about this 5 years ago. We talked about this when fix and flips were really happening a lot. But now we're seeing misrepresentation claims. Now we're seeing non-disclosure issues. And I think it has to do with 2 different issues. Number one, the market, buyers just want to get in. They're waiving inspections. They're not doing inspections. They're not following up. They don't care what the inspector is saying. They just want a house. And so then they get into this situation where, something hasn't been disclosed. There are issues with the property. And now they want to go after the seller or the listing agent for non-disclosure. For whatever reason, we have seen a huge uptick in those probably over the last 2 or 3 months. The other reason I think that that's happening is because all of the rain we've had. And so a lot of times problems surface when the rain is hitting the roof, when puddling and ponding is happening near a pool or in the backyard, or there's water that's sitting up against the structure or the foundation of a home. And so we're starting to see these. And so those are usually cyclical. So 2008, 2009, 2010, we saw a lot of them when people would buy these foreclosure homes, turn around, fix and flip them. Then 2014, 2015, people were getting into the market and doing a lot of fix and flips. And so we saw some shoddy workmanship there and some other issues. So there was a lot of misrepresentation and non-disclosure situations. And now we're seeing them because people just jump into houses. And so it's very important that folks aren't just waiving rights. At the very least, get an inspection so you know what you're going to be dealing with. But we've seen so many people who are now submitting an offer with the bins are checked off, saying they've done all the inspections when they didn't necessarily need to do that to get the deal. They do an inspection, even if you're not going to ask for bins or items, still do an inspection. So you at least know whether you're going to be spending $75,000 in the next couple of years to fix certain issues. And then, of course, I can't do anything about the rains, but that seems to be pushing out a lot of these issues and making them more well-known than perhaps, what we've seen in the past. So those are kind of the three top issues that we've seen: the push for PLLCs, the specific performance, and then the misrepresentation and non-disclosure issues seem to be ramping back up. Now let's talk about the cases and the decisions that have come out over the last year or so, or that literally some of these have come out over the last month. We get our laws either by statute or from the Arizona Court of Appeals or the Arizona Supreme Court. Some of which, or some of the cases we also get from the Ninth Circuit Court of Appeals, which is the federal court system, okay, that we're sort of bound by, right? California, a couple other states are within the Ninth Circuit Court of Appeals on the federal side. So these are some cases, they're listed here. There's about 4 of them listed here that will have an effect, I think, on real estate transactions, on some of your clients, perhaps on the industry. The first is this Zambrano case. The case came out literally at the end of July. And so it came out from the Court of Appeals. And this involved new construction. It involved a home builder, right? And the home builder, through their sort of standard form real estate contract, their builder contract, or their new build contract, got the purchasers to provide a disclaimer or a waiver, multiple things here actually, or an agreement to forego the right to seek implied warranties. Okay, implied warranties of workmanship, implied warranties of habitability, those types of things. And so in a traditional construction contract, or in a traditional builder contract that we'll see with the big home builders, there will be express warranties. The builder hereby provides this express warranty that the roof will be watertight for the next year, or that we will guarantee the workmanship of these particular structural portions for a year or for 2 years, whatever that is. So express just refers to it being written. Well, under Arizona law, we also have what are called implied warranties. And basically, implied warranties are just that. If it's not expressly written, well, we're entitled to some warranties. We're entitled to some guarantees that, for instance, that systems work. Even if the builder didn't put anything in the contract itself saying these particular systems will work, well, we can rely on what are called implied warranties to go after that builder if we have to say, well, it was implied that you weren't just throwing mud and creating a hut for me, that I was going to get certain benefits from this property. And if something doesn't work or it breaks and it's not expressly provided in the contract, well, implicitly it's provided. Implicitly, we know that we can go after the buyer or the builder because these are just the things that the builder knows better, and the builder has more access to, and the law sort of implies these warranties. Okay, well, what the builder did here was they tried to get the purchasers to waive and to sign off that they wouldn't ever pursue these implied warranties. So what they did was they gave a very limited or skimpy express warranty that said for the next year, we're going to make sure that the roof is airtight and a couple of other, or watertight and a couple of other things. And you specifically agree to waive your right to pursue us under any of these implied warranty theories. Okay. And so this ultimately went to the trial court level and said, no, this is something that we can't waive. The Court of Appeals of Arizona just came out and said, that's right. It's good public policy to require builders provide implied warranties. And the theory of caveat emptor, buyer beware, no longer exists. So it's really not on the buyer to discover these issues. It's really on the builder to make sure that they're providing a good product. Okay, so there is an obligation to honor implied warranties, and the builders can't get away with some of that sneaky language that they've used. So the risk of a defect is not necessarily always going to be on the buyer. Okay, and so this sort of just gets to the whole point of, you know, people not reading their contracts. You know, people shouldn't be expressly waiving warranties at all. People shouldn't be, you know, disregarding what this builder is putting in bold and black and 16-point font. But every day we know that happens. Every day we know that folks aren't reading these contracts. So to me, this sort of goes to the point that you really need to hone in on your buyers reviewing the contracts, asking whatever questions they have about a construction contract. Okay, so the law says these things cannot be waived, but who knows what else we're being asked to waive. And so your clients need to know what specifically they're waiving in those new build contracts. Those new build contracts are very one-sided. Some of those waivers are allowed, some of them are not. So it's very, very important that your buyers read those documents and understand what's going on. So that's really the lesson of those. And so again, first issue that just came out is the fact that people cannot, or builders cannot require, or it's unenforceable if a builder requires the waiver of implied warranties. Okay, so very important in the construction industry, very important for the new builds, and that's the Zambrano case. Now that case could very well go to the Arizona Supreme Court because there's a big builder push to say, yeah, people can waive whatever they want to waive. And if they want this property bad enough, they need to waive it on my terms. So who knows? That was sort of the builder's push and the builder's argument the whole time. And the builders are well protected under our Arizona statutes. And so they're going to continue to push that issue and say, look, we can make people waive whatever we want. I think ultimately the decision came out correctly here. There are certain things that buyers are just so not sophisticated to know that they shouldn't be waiving, you know, what they are getting and what they're usually entitled to. Okay, so that's case number one. This in re brace is another case. This one came out of the Federal Circuit Court, the Ninth Circuit. In re brace, the titling of this caption or this case, in re, either means that somebody died or somebody filed bankruptcy. So those are how we caption or reference a case. This one particularly was a bankruptcy case. This one again was a Ninth Circuit decision. The issue was over the manner in which title is taken in states that have community property. This is a huge issue as I see it, because what I see are people who don't understand the manner in which they should properly take title to real estate. So the ultimate conclusion in this case was that if a married couple acquires real estate, it is presumed that they did it on behalf of the community, that it's going to be considered community property. And there are certain reasons why a married couple might not want that outcome, might not want that presumption to apply. If there's an inheritance, if there's a prenup, if there's a bankruptcy of one of the spouses. And in this particular instance, what this couple was trying to do was they were trying to protect a house by arguing that it wasn't community property. Well, guess what? They mistitled stuff. They didn't have a separate agreement outlining the manner in which this particular property was going to be titled. Therefore, it was deemed community property. That's going to be the same outcome in Arizona as well. Okay, so it really brought out the fact that people don't understand or are just checking the box when the title company sends, how do you want your warranty deed to read? They're just checking a box based on prior conclusions or prior transactions. And it really, you know, drives home the point that, you know, people need this education and not just check the box that says, hey, I agree to take this as joint tenants with right of survivor, or hey, I agree to take this in the name of my trust. We really need to be careful in the manner in which we are taking, a buyer is taking title, because it could have a huge effect. These folks lost this property through bankruptcy, which was not their intent. Okay. And so, whenever somebody asks you about this situation, and this question may come up, how do I take title? Sometimes it comes up for the title company. Well, in many instances, a 20-minute call with me or with an attorney or another real estate attorney can hone in on what those people need to take title as. Okay. And you can reverse what you've done. You can undo what you've done unless somebody dies, unless somebody files bankruptcy, unless there's a divorce. Okay. So usually that can be unwound. Usually that can be cleaned up. Usually that can be fixed. But in this particular instance, it couldn't be because it was too late. Okay. And so, people want to know, should I take this in the name of my trust? Should I take this in the name of my LLC? Should I take this as a joint tenant with right of survivorship? Should I take this as community property with right of survivorship? Should I do this as a tenant in common? People are goofing that up. People are goofing up the designation because they really don't understand it. And so if you need, I have some kind of cheat sheet or notes on how to sort of, guide people when making that decision. I don't want to make the decision for them. I just want them to know, hey, these are your options. This is the consequence, including the consequence that happened in this bankruptcy court. So if you guys want my notes, it's kind of a little flow chart on how that works. Might be helpful. Again, as real estate agents, I don't know that it's your job to tell them the manner in which to take title. I don't think I would do that. I would just say, these are the options. Here's a checklist I got from an attorney. You might want to check with him or that checklist. Okay. So big issue number one comes in the construction industry, comes in the fact that we need to be reading what the builders are actually putting in these documents. And that's sort of proof of that. Second one comes in the bankruptcy world and really deals with title and really deals with the situation where people lost the property thinking that it wasn't community property and maybe that wasn't their intent. Maybe it was, but they ultimately lost this property that they were trying to keep. And so there are these strong presumptions. And in that case, again, had they sort of understood the way in which they're titling the asset, they could have kept the asset. Okay. The third case comes to us from the landlord-tenant realm, and it's this Ibarra case. This was an Arizona Court of Appeals case, kind of entertaining. And by the way, it has nothing to do with the moratorium, thank God. We'll be getting enough case law on that pretty quickly here. But this is a landlord-tenant dispute that a tenant in a rental property stubbed his toe on a crack in the floor and of a residential rental, and he said he was injured. And the tenant claimed that he made repeated requests to the landlord to fix, this crack in the floor. Tenant then turns around and sues the landlord under the Landlord-Tenant Act. And the Landlord-Tenant Act, as you probably know, requires that a landlord keep the premises in a fit and habitable condition. Well, the tenant said, hey, this crack that I stubbed my toe on violated the Landlord-Tenant Act because it wasn't a fit and habitable condition. And the act of violating the Landlord-Tenant Act constituted negligence or automatic negligence or negligence per se. And all I now have to do is show what my damages are. So basically the issue was whether someone who stubs their toe can sue a landlord under the Landlord-Tenant Act for negligence. Does it mean that the landlord is automatically negligent? The answer was no. And the Court of Appeals said, nice try. The Landlord-Tenant Act is just there to provide a general statement about what should be done. It doesn't mean that falling below those items automatically constitutes negligence, automatically means a tenant is entitled to damages. It's just a general statement about the way in which landlords need to conduct themselves. Had it been landlords must, prevent cracks and people from stubbing their toes, well then, yeah, there's probably, negligence per se or automatic negligence in that particular situation. So the lesson there is really the Landlord-Tenant Act are these general obligations of a landlord. They're not intended to create this standard of care. Rather, there's sort of this general idea that things need to be taken care of. Doesn't mean that there's automatically liable for negligence. So that's good for landlords who have had a rough go of it the last year and a half now. The other finding in that particular case was basically about the strength of a limited liability company. And the landlord had the rental property in the name of a limited liability company. He had an LLC for it. And what the tenant was trying to do was saying, hey, look, you violated this statute. You were acting, outside of the scope of what the LLC is really trying to do here. You knew about these personally, so I'm going to sue you personally, and I'm going to sue the LLC. And the court said no. The court said that alter ego theory just doesn't work. You really have to show a lot of intermingling of assets, a lot of fraud in order to defeat the LLC. So there's a little bit of support there that sort of shows that Arizona courts are willing to uphold the corporate form of an LLC, which is really, really good news. Okay, so we talked about the construction industry, and reading those documents, very important, because it kind of shows that the builders were being a little sneaky, trying to get away with stuff, and that we still need to make sure we're reading those, but they can't ultimately get away with that stuff, at least not right now. Second one, it was the interpretation of the manner in which people title the property. And there's a presumption that there's automatic community property. There are ways to rebut that presumption. There are documents you can use to rebut that presumption, but it's very important to have the correct titling to your property, the manner in which you hold title. And then we had this third case coming out of the landlord-tenant realm, which basically upheld the strength of LLCs, which basically also said, look, the Landlord-Tenant Act in and of itself is sort of this general statute of a general standard of care, and it doesn't automatically mean somebody's negligent if they fail to maintain. It just means they need to maintain. Okay. Fourth case is the CK revocable trust case. And it involved a commission. So I see your ears perking up now. The case was CK revocable trust versus My Home Group, and the issue was about technical broker requirements for a commission versus substantive broker requirements for a commission. Okay, so there are technical requirements imposed by the ADRE, your commissioner standards, various real estate statutes, and there are substantive laws that are covered by those by the ADRE's commissioner standards and statutes. Okay, in this particular instance, there was a listing agreement. Okay. And there was a listing agreement. The brokerage ultimately sought to collect the commission based on a sale by the seller. Okay, so there was a listing agreement. There was a bit of a dispute between the listing agent and the listing brokerage and the seller. Ultimately, seller goes around behind the back of the listing agent, sells the property to somebody else, so that the brokerage then comes and says, hey, we just saw what you did. We want our commission. Okay. And so the seller says, no, I'm not going to pay you. I'm not going to give you this commission. And, brokerage is like, well, you signed this listing agreement. It obligates you to pay a commission. We want our commission. And the reason that the seller didn't want to pay the commission, and he said, well, I'm not paying the commission because the brokerage didn't initial the listing agreement within 10 days as required by statute. And so they were trying to get off on this technicality that says, well, you missed this by a day or two. You didn't initial this as required by statute. Therefore, we don't have to pay you a commission. So the question for the Court of Appeals was whether this non-compliance could invalidate the obligation of this seller to pay a commission. What do you guys think happened there? Do you think that the brokerage was entitled to a commission? Anybody want to throw it in the chat? Anybody? So lots of people saying probably yes, yes, yes. And the answer is yes. And somebody said no. So that's a good one. I mean, it was enough of an issue that it had to be addressed by a high court in Arizona. Okay. And so the answer is yes, the brokerage got a commission. And what the Court of Appeals did was they basically said, look, there are technical requirements of these ADRE and Arizona real estate statutes, and there are substantive ones. The violation of a technical statute or a technical requirement doesn't mean you can get out of having to pay a commission. If there was substantive non-compliance, then there would be no commission owed. Substantive compliance means license at the time the commission is owed, listing agreement needs to be in writing and signed. But the sort of technical items, the checking off of boxes, didn't necessarily need to be complied with. Okay, so there was a difference between these technical and very substantive rules. And technical, the court also said technical noncompliance will get you in trouble with the Arizona Department of Real Estate. Substantive noncompliance will get your commission yanked altogether. So the lesson there is basically make sure your brokers are signing off on these items. Make sure you're dotting all your T's and crossing or dotting your I's and crossing your T's, because we want to make sure that this issue doesn't come up again. Okay, and so had this been just the broker just signed off on it in 10 days like they were supposed to, well, guess what? These folks would have not spent $40,000, $50,000, $60,000 in litigating this issue. Okay, so we got to make sure that we're complying with the substantive requirements and the technical requirements. The technical requirements, failure to comply with them will get you in trouble with the ADRE. Substantive, failure to follow substantive requirements, licensed at the time that the commission is owed, listing agreement signed and in writing, that'll get your commission yanked. Okay, so that was the distinction there. But the bottom line is you got to make sure that everybody's complying with your obligations, whether they're technical or substantive. Now, those are the 4 or so cases. But yeah, Wainwright's must have been a large commission. It was very large. Yeah, and it was well worth it to push that issue in that particular situation. Yeah, for a $5,000 commission, nobody's going to the Court of Appeals over that. They're going to settle that or split the difference or something. This was a very large multi-million-dollar property that was sold, and probably some hard feelings on both sides about whether a commission was owed in the first place. And so, when some people have more money to spend than they know what to do with, they're willing to push that issue just to be right. I think that was partially what was going on there. So those are the 4 cases or 4 or 5 cases that we're going to see going into 2022, with perhaps some effect on real estate agents, on transactions, on the form of contracts, on perhaps some addendums as well. Okay, a couple of other quick topics before I end, and I'll open it up. Did the second agent who sold the house was able to keep his commission? That's correct, Raj. Yes, they were. All the agents got paid on this one, and ultimately paid. Took a while. A couple of other items to be mindful of or to keep abreast of. There's House Bill 2805, which basically says an unlicensed individual can collect rent and other fees as part of their job working for a licensed real estate brokerage. That's going to help out, make the lives of property management companies a little bit easier. That may apply to some of you out there. That's a new one coming into effect. The other one that's a big one, I think, is this new Homestead Exemption. And I'm going to talk about it. I mentioned it on a prior class, but this is going to have some significant effect on people and on transactions. I'll tell you why. So the new Homestead Exemption, basically a Homestead Exemption says, look, you are going to have protection. You are going to be entitled to a certain amount of equity in your property, no matter what. So if you have a bunch of creditors coming after you, and you ultimately sell your house, well, you're entitled to that first $150,000 if it's your primary residence and you resided there. Okay, so if you can prove these couple of elements, they can't touch that $150,000 of equity. Okay, great. So the Homestead Exemption is protection. That's why people move to Florida or Texas, because some of these states have unlimited homestead exemptions. Well, ours right now is $150,000. So those states are popular. That's why OJ moved to Florida. Maybe one of the reasons, or to play more golf, whatever. But that was why a lot of people either move to Texas or to Florida, is because there are unlimited homestead exemptions. Well, we have a pretty good one here in Arizona. It's $150,000. You get to keep it no matter what. If you have creditors coming after you, you get to keep your first $150,000 until the law changes January 1st, 2022. Okay, so the new act actually protects more money. The exemption amount goes to $250,000. But, and it's a big but, because it ultimately eviscerates or eradicates a lot of your protection. Okay, so yes, the monetary amount is higher, it's $250,000, but the new statute will retroactively and automatically turn existing judgments and new judgments into liens against the owner's property. So right now, if there's a judgment against somebody, it's really not a lien against the property because you're entitled to $150,000. Well, now the statute changes entirely. Those are triggered into liens and they're going to be paid off at close of escrow. So we've essentially eviscerated or removed the protection. Now we've bumped up the monetary amount, but for people who have judgments against them, you can't go and say, hey, I'm entitled to this first $250,000 now. I'm entitled to this first $150,000 now. No, those with recorded liens, recorded judgments get paid first now, when right now that's not necessarily how it works. So there's a couple of things that are going to happen. I think that there may be more bankruptcy filings to try to get rid of those liens and to try to eradicate those judgments. And I think it's going to slow down some real estate transactions because title companies are now going to have sort of a waiting period to discuss the matter with the creditors as to how much is owed and to how this is sort of how this homestead exemption is going to play itself out. So I would expect that some transactions are going to be delayed. So do the liens force someone to sell to pay them off? Pretty much, Wayne. That's exactly. You can as a lien holder, you have the right to foreclose that lien, but nobody's going to do that if there's homestead property. Well, now they can do it, or they get paid at a closing. So that's going to change things a little bit. So that's yes, Wayne. The answer to your question is yes. Greg asked, what was the impetus for the change? I don't know. It was a real estate attorney here in town. He's pretty well known, who actually drafted the law, and he represents a lot of creditors, a lot of banks, a lot of people who have judgments. And so perhaps he was trying to create some change, trying to create some new laws, but trying to protect the creditors out there. This is going to perhaps slow down real estate transactions, purchases and sales. And if somebody's doing a refinance, they really need to do it now in case there's any liens out there, because otherwise that's going to muck this whole thing up. And that lien is not going to go away. You're probably going to have to pay it off no matter what in connection with a refi. So those are the two statutes that I think are probably going to have the biggest effect, at least right now, on future real estate transactions. Those both go into effect at the beginning of the year, the property management one, and then this new Homestead Act, which to me, it really eradicates the protection that we had in the first place. That it's sort of they threw the debtors or the owners a little bit of a bone by increasing the amount, but ultimately, if you got a lot of judgments, you're not getting out of that one. So somebody had a question about the Zambrano case. Did they have a buyer agent and did they sue the agent? Did they have a buyer agent and did they sue that agent broker too? So the Zambrano one was the construction issue. So I think you're talking about the revocable trust one, and the answer is no. They didn't sue. It was actually the brokerage that sued the seller. In that particular instance, the seller turns around and says, "Hold on, I have this defense. You didn't meet the technical requirements." So the buyer's agent really wasn't involved in that one. They ultimately got paid once this commission was paid out, or once the judgment was enforced, but no, they didn't include the buyer's agent in that one. What if the house is under an LLC, under an LLC's name regarding the liens? That's an interesting question, Sonia. I think you're going to be fine in a situation like that, or I think that the owner would be fine in a situation like that. I would really defer to the underwriters at title to determine what it's specifically they're going to do in those situations, because in some situations they're going to say this lien needs to be paid off. We don't care if it's an LLC or an individual name, but in other situations, if it's an LLC, then there is that protection. And the best that the creditor can do is obtain what's called a charging order. So I really think the homestead exemption isn't going to apply to an LLC. But what can happen is that the title companies can get tripped up and say, look, we're not going to provide this LLC with any protection, then you have to sort of go and petition with the title company and say, look, this is an LLC, it has nothing to do with the ultimate owner or the owner of the LLC. This is a separate entity. So in those situations, there is no homestead exemption because it's an LLC. And in most situations, the best case scenario, which is why you have an LLC, is that they can go after a distribution of an LLC asset. Well, don't distribute anything then. It's called a charging order. You have to sit on that for a very long time if you're a creditor. So that's the real benefit of an LLC. So the LLC really isn't going to have any effect on the homestead exemption, but you do need to get comfortable, or the title company is going to need to get comfortable that this is a legitimate LLC and that it's not sort of one and the same as the individual who has those liens against them. Hopefully I articulated that correctly or understandably, because there's actually a lot to that question that you asked me. So if a sale is forced, after the sale, the home goes away, now the proceeds from the sale less than $250,000 are no longer protected by the homestead exemption. Pretty much. Yep, that's right. That's right, Wayne. You nailed it. So there's really no homestead protection anymore in a lot of situations. Is what we're going to be finding is that they've eviscerated it. The homestead exemption is now largely going to be gone, and that's frustrating for a whole lot of people, and it's going to slow down transactions. So what happens in those situations? More people have to file bankruptcy. So it's good for bankruptcy attorneys, but it doesn't really do homeowners that much good. It's a lot, a lot of stuff. If you guys need memos, if you need checklists, if you want my notes, shoot me an email after this. I'll put my information in the chat box, but these are some fun stuff. I have 2 points to discuss: implied warranty, procuring cause if the time permits. Shane, we got time? Shane's giving me the thumbs up, so go ahead, Raj.
Hey, Patrick, thank you so much. Again, as always, very informative session by you, so appreciate it. Real quick, these 2 points. One is the implied warranty. I just wrote, or actually my buyer, he just signed a contract. Well, I should say partially signed the contract, not finalized yet. Builder's new home build contract. And there are so many loopholes, everything in favor of the builder, and pretty much the builder can cancel the sale when the house is complete 10 months or a year down the road. So the builders are taking away more and more rights, and to your point, they are making the consumer waive those rights. And if the consumer objects that he's not comfortable, builders is pretty much showing them the door that no, we can't change anything, either take it or leave it. Understandable right now, the demand is high, so builders are pretty much getting their way. But if we go and buy a used car from a used car dealer today, even a $20,000 car, comes with some warranty in some or the other shape. But when we try to go buy a house, it's pretty much builders are trying to get their way. It's funny.
It's pretty wild, and I totally get your point there that these builder contracts are just getting more and more onerous and more protective of the builders, and they take or leave it approach. And what we see are a lot of situations in which people will sign these, not understanding what they're waiving, and then they encounter a problem, and then they look at the contract and go, well, I can't do anything about it anyway. I waived this. And so there is this big sort of dissuasive is a word, I don't know, but people are dissuaded from doing anything. And even though they can do stuff, even though those implied warranties aren't truly waived, even though the seller probably really can't cancel in a situation like that, it makes the contract illusory, which means it's based on illusion. Essentially, it's an unenforceable provision with the 10-month thing that you mentioned. People don't know that, and then they think that it's, oh, I signed this contract, but no, there's Arizona law that says you can't just go and string somebody along for 10 months and then pull the wool out, pull the wool out from over their head and do that. And you can't require that they waive certain protections that Arizona law finds to be, helpful to people. So, they are getting away with a lot in these contracts. The contracts are extremely onerous, and their hope is that, hey, nobody ever calls us on this. For instance, there are warranties in there or statements about warranties that say, look, these are issues that you must raise in the first year. Otherwise you waive them. Well, we all know that that's not true. It's a 2-year statute of limitations, no matter what, if you want to go to the RLC. And they're in there including it as a 1 year, and as if it's sort of the gospel. It's not the case. And so a lot of people have just become so frustrated or dissuaded from going after a contractor or going after their builder that they just give up. There's also, we may have talked about this on a prior webinar, but there's also what's called the Purchaser Dwelling Act. And that is probably the least consumer-friendly statute in America. But basically, it requires a owner to go through many rounds of letter writing to actually get to actually force a response by the home builder to whatever problems there are. And it takes time, and sometimes they just give up, or sometimes they've waited so long to do anything legally that they've blown past their statute of limitations. And I think that that's part of why that Purchaser Dwelling Act exists. It's to hope that people go through this process, lose their statute of limitations, and then they're out of luck anyway. And so it's an uphill battle against the builders, and there's a lot of legislation that protects them. So
yes. Yeah. So, and I want to point out another practice of deception that's being carried out. So in this case, I have an investor client who wanted to purchase a home that you could legally, legitimately rent it out after purchasing. And most of the builders not allowing this. So I called about 40 communities, about 4 were allowing. So we approached one. First question was, are you allowing investor purchase? Answer was yes, definitive yes. And everything, a floor plan is selected. The contract is submitted to the buyer for signature. The buyer wired the earnest deposit, and then started reading that 100-page contract, him and I both. So we found a clause saying that the home is for purchase only by either primary or secondary homeowner. And we brought it to the salesperson's attention that, hey, you say that this is available to investor. And she says, oh, you want to rent it out, right? No one is going to mind. No one is going to object. You can just buy it. So it was like a hush, hush, wink, wink, buy. No one's going to say anything. And we raised the issue. No, we want to buy only legitimate home that allows the buyer is not going to live in that home, either primary or secondary a homeowner, so wants to rent it out. And we again got these wink, wink answers. And so we said, okay, either you remove the clause or have an addendum that overrides that clause, or return our earnest deposit. So we got, after about 48 hours, we got a 1-line reply. You will get your earnest deposit back after several weeks. No other explanation provided. So this is what the practice is being performed. I won't say by most builders, but some deceptive salespeople. So just be careful out there.
And I've run into situations where that specific thing happens, and you get to closing, and then you see this addendum, or you see this attachment to a deed that says, and I covenant not to rent this out for a year, or that this is my primary residence, when all along everybody knew that this was going to be provided to an investor who's going to rent it out. So once you learn of that, try to get something in writing. Try to sort of send that email that says, hey, so-and-so at the sales office, you specifically said this, please confirm that I'm correct, please confirm that I'm incorrect. Maybe you get them to respond, maybe not, but that's what I would do, is I would try to get them to put something in writing immediately. Once you hear that representation, ultimately they're probably going to ignore you, but I've seen that happen. and I know exactly what you're talking about. And in some instances, you really have to raise a stink about the issue, because the builder is saying, I don't know what you're talking about. We're not giving you your money back. And then it becomes an even bigger issue, because now you're out $25,000 plus some improvements and et cetera, maybe more. So yeah, that's a scary one.
Yeah. So Patrick, I want to raise little, attention, concern. Who is the authority that I need to bring it up to so that other people don't get burned, other buyers?
Yeah, I would say that it's an ADRE issue as to that sales that sales agent.
Okay.
I think.
Great.
Yep.
Great. And real quick, the second issue is about the procuring cause. So again, new build homes. Now when we take our buyers for registration, the registration used to be valid for 6 months, then they changed it to 3 months. Now it's only 30 days. And after 30 days, if the buyer doesn't take an action, the builders are very, they pursue that buyer endlessly until the buyer is purchasing. And at that time, if it's past 30 days, they easily cut the real estate agent out of the equation, and they try to sell it directly to the buyer. Now, on the other side, if the buyer goes to builder's office, although the buyer may be working with the agent, but not knowing, if the buyer goes there and then realizes next day that, oh, I'm working with an agent, and tells the builder says, sorry, he wasn't there, the agent wasn't there, so we can't anyone represent you. And now that registration runs in perpetuity forever. However, the agent registration expires after 30 days. Is there any statute to protect the realtors against this unfair treatment?
I wish there was, and in the times that I've seen this come up, it's sort of like, oh my gosh, this is terrible, because you're cutting me out, and this sort of seems scammy. All I say to people is, well, eventually the tide will turn. The builders will need the buyer's brokers again, or buyer's agents again. But there are some legal theories that you can use to sort of capture a commission or a payment. It's the theory of unjust enrichment. There's some other sort of equitable principles that we've used in the past to say, look, you just can't do this. And it's worked to some degree. Sometimes it doesn't work, but it's sort of like, you need to pay up here. You need to do something here. That I did this, and you cut me out. I truly was the cause of this sale, and I delivered what I needed to deliver in terms of a ready, willing, and able buyer. And so, we use these, quasi legal theories to try to push the issue, but I don't know of any statutes. And unfortunately, there's, from a very highly technical standpoint, I don't know what you can do. And that's a frustrating proposition, other than to say, well, this isn't going to last forever. You guys are spiting us now. And so, we'll have to we'll see you on the flip side of this. I don't know. Looks like somebody else put in there, there'll be good times. There are good times for builders. The tide will turn, and there's really nothing you can do. I agree with that largely. I mean, we've tried it, and we've had some success, but it's a annoying, frustrating process. It's a sort of unjust enrichment theory that says, look, I did all of this work, and you can't just cut me out. I'm entitled to something. There was value in what I produced. For instance, if somebody comes and mows my lawn, and I see him, and I never really wanted him to mow my lawn, and we don't have a contract, but I just let him finish mowing my lawn, well, I can't just say, I don't owe you anything. There's an unjust enrichment theory there that says he did something, I didn't stop him from doing something, he's entitled to at least something, right? So that one sometimes works, but normally it's an uphill battle. Okay.
Yeah, thanks for answering those.
Yeah, of course. Let me just see some of these other questions here. Somebody had, okay, do owners of rental property have to have a sales tax license if they're renting to a family member. Joanne, I don't know. That's a good question. I assume the answer is yes, but I don't know that for sure. I would probably talk to a CPA. Looks like Wayne had a question as well. Sorry, Joanne, I just don't know the answer to that one. Wayne says he has a question regarding standard of care regarding agents. Wayne, you want to ask it?
Sure. When we're in a tight market like this, and let's say a client requests waiving the appraisal and waiving the inspection, what kind of risk does that put us in as agents? We really don't want to do that, but the client wants us to do it. Sorry about
Yeah,
that.
no, that's a great question. And so you're basically saying, well, look, I'm a sitting duck here, essentially, because this client is pushing me to, waive certain of their rights. I don't think it's a good idea. It's not standard. It's, waiving appraisals, etc. What we recommend is some sort of little statement or document that basically outlines, hey, look, you have advised us that this is what you want to do. We typically recommend against this. Here are the risks associated with this. If you're still okay with this, sign off here and I'll make that offer. And so you're at least getting something in writing outlining that they understood the risk and they knew the risk and they were going to move forward with the purchasing property notwithstanding that risk. So we've created some kind of release documents or waiver documents. I don't know if they're enforceable or not. I would assume they're going to be fine because these people are pushing you guys to go above and beyond. But I wouldn't just go and do it based on a verbal. I wouldn't go and do it just based on a text message. I would get them something that says, you have asked me to do X, Y, and Z. This is not the standard of care for real estate agents to continue on in a transaction like this. If you really want to do this, you need to, acknowledge that I've informed you of these risks. So it's kind of this informed consent idea. And it seems to have paid off in some instances. And frankly, there are some agents out there who will actually recommend that their clients go and do those. So I definitely would shy away from that. If a client approaches you and says that they're willing to do those items, then I think you get that sort of written waiver or agreement that says, that this is that you're doing this on your own volition, and I've warned you of these risks. So as long as they're warned of the risk, then I think that you're fine. But I would get them to waive that and sign that in writing that they understand what it is that's wrong with what they're proposing.
Yeah, that makes sense. Thank you.
You bet. So somebody's asking about the home title locks. Can somebody really steal your title without you knowing it? I applaud those companies for coming up with a business model to sort of pretend like there's an issue here. And maybe it's an issue in other states. We just don't see a lot of that in Arizona. I've seen people who, have deeds forged and those types of things. And that's largely what title insurance is going to protect you against, is a situation like that. So it's more of a monitoring. It's more of a monitoring device as I see it. I haven't really got into them because, again, we don't, stealing title or forging documents probably comes up once or twice a year for us. The title companies do a pretty good job of sort of making sure that that's not happening. They're issuing title insurance. And so, yes, it could happen, but I don't know. I think in most situations, title insurance actually protects you against that. Perhaps what this service really is just a monitoring thing that says, look, we found this recorded against your title. You might want to do something about this. As opposed to, somebody taking title without you knowing it. Taking title without somebody knowing it would really require an improper foreclosure action and a quieting of title action to really dispossess somebody of property. And you're going to have plenty of notice that those things are coming down the pipeline. There are service requirements that you be served. A court's not going to just rubber stamp the stealing of somebody's property unless they're happy with the way in which people were served, that people were notified. So to me, those are largely companies. Sure, that stuff happens, but there's a way to protect yourself, and that's title insurance. And for me, those are, as I understand them, they're more of a monitoring service that just says, hey, look, we just found something on your recorded against your property. You might want to take a look at this. So I don't know if that answers your question or not. We just don't see a lot of theft or recording of false documents. And by the way, under Arizona law, we have what's called ARS 33420, and that is a very strong statute. And it's a title related statute. And it basically says, look, if anybody's recording something against title to your property and you catch them, they owe you your damages for them recording it multiplied by 3 plus your attorney's fees. So there is this big statute that says, look, if somebody records something and it's improper and you can show that it's improper, you take them to court, you get that lien released immediately, and you get a judgment for a lot of money for if they've messed up your sale, if they messed up something else. So I'm not a huge proponent of those home title lock types of things. I don't know that they're really doing much other than monitoring. So hopefully that answers the question. So somebody's asking 33420. 33420, look, that is a very powerful statute that allows you to recover damages. It allows you to get in front of a judge almost immediately. There's a mechanism that not a lot of people know about under that statute, which basically says, hey, if there's something affecting title, you can petition to get in before a judge to have that removed, the lien removed, or the improper cloud on title removed within 7 to 10 days. Plus get a judgment for your attorney's fees, etc. So sometimes somebody will record a notice of lis pendens and there's no basis for it. Or they'll record a mechanic's lien, or they'll record some sort of memorandum that says, you owe me this, I owe you that, whatever. And they're not permitted. And in those situations, we go right after them under 33420, we get that lien removed, and then we get them damages. And the courts are very willing to grant that. So again, this gets into the title protection. I think that the title lock stuff, maybe there's a need for it somewhere. If people aren't sophisticated enough to look up their own title documents or see what's been recorded against their property. But title insurance is usually going to protect against something like that. We also have statutes that protect against the unlawful recording. Maybe the title lock gets you to figure it out quicker, but you still got to do something. You still have to take some action. So Shane, I don't know, have you seen that come up much, the title lock protection?
No, boy, I think it was last year or last year and a half. I had a lot of questions about it, and our corporate counsel here, Mike Gable, wrote a whole article about that. No, they're here to take your money. Basically, he thought it was sort of an offshoot of like LifeLock at the time, and this was a year and a half ago or whatever. He thought it was the same principles. And it's like, nope, don't buy into that.
Yeah, I think that there's plenty of other ways to protect title, and the primary one is title insurance, and then of course the other ones are these statutes. And somebody's asking, where do you get a chance to read ARS 33420? If you just type in a Google search, it should pop up. Or wrongful lien statute in Arizona, that sort of stuff. I can also send some links. I'll put my email address here again in the chat, just in case anybody wants to set up a call or anything like that, or wants any of these documents. We have plenty of stuff. Happy to give it out. Well, it sounds, Shane, like that your in-house attorney is kind of on the same page as me, that this may not be the best product out there.
No, he shot it down pretty quick. But yeah, I had a whole article. I think I might have posted it on Facebook at the time. I'm like, can I post this? Because I had a lot of questions about it. It became a late night thing where people were like, oh my God. And yeah.
Yeah, it's just not that easy. Again, we see people forging documents. We see notary fraud, but it's very, very rare. So somebody wrote, one thing they do is to steal title as a quick claim deed. Yeah, sure. And I agree. And I wonder how that works. Well, it's usually a forged one. It's usually somebody who doesn't have the mental capacity to know what they're actually signing. It's usually a notary who's in on it as well. And that's what they do. And then ultimately though, let's say that I sign, somebody signs my name on title to a quitclaim deed purporting to be me, conveying my interest in my house or whatever to somebody else. Well, somebody's gonna have to show up at my doorstep to say, hey, I got title, this is my house. And I'm gonna say, no, you don't. And we're gonna go to court over it. And then there'll be, a handwriting analysis and some discussions with the notary there as to what identification that they actually received. And so, the risk of that actually playing itself out is probably pretty low. It happens. There's some bad actors out there, but it's rare. So all I got, guys. Hopefully you're cranking away, having a good rest of your week, and September already. So hopefully the weather will start cooling off, a little patio weather.
Absolutely. And we'll be back here Wednesday, October 6th with part 2. I love it.
Part 2, let's do it. All right. We'll see you guys.
Everyone.
Have a great rest of your day.